guys, it's Christina with Contour Salon Studio, and today we're going to be talking about non-competes. I will be interviewing Daniel Etlinger, and he is with Jennis law firm. And one of the reasons I chose to do non-competes is because I think it's so important for people to be able to navigate non-competes. Some people don't even know what that is or how it could affect them and their business. So I'm really excited to go talk to Daniel and hear what he has to say. We are here at Jennis law firm. We're about to interview Daniel Etlinger.
A non-compete is really an agreement where somebody says, I'm not going to work for a competitor or a conflicting business. And it's part of a bigger umbrella of restrictive covenants, meaning somebody's agreeing to limit what they can do.
Okay.
So a lot of times you'll see a non-compete in tandem with a non-solicitation agreement, meaning we can't try to get your customers or your employees. You may see it in conjunction with a non-disparagement clause, meaning we aren't going to say bad things about one another.
Right.
Employers think that they can do whatever they want in a non-compete, and that just simply isn't the case. Courts will typically look at if they're reasonable in time, geography, what type of work you do, the overall reasonableness. So there are some constraints. And the other misconception I see a lot of times is that employers will try to use them for independent contractors.
Okay.
1099s.
Which means?
Well, it kind of flies in the face of what an independent contractor is. That's someone who's not beholden to any one particular company. So,
like freelancing, working for themselves.
Exactly. So the non-compete is kind of in a direct conflict with what you would think of for an independent contractor. And the response I get a lot of times is, well, best case scenario, they'll abide by it. Worst case scenario, a court will throw it out and I'm no worse off. But I just don't think that's the case.
Right.
There's kind of two dangers there. Mm-hmm. The first is an independent contractor versus an employee is a fluid test. And just because your contract says one thing, if you treat them like an employee, they can be reclassified as an employee. So if you make them sign a non-compete, well, that gives ammunition to the IRS or anyone else to reclassify that person.
Right.
And the second danger there is that there's a statutory attorney's fee provision. So if you have them sign a non-compete and they prevail, well, they could get their attorney's fees and costs against you.
Okay, right.
So there is some drawbacks to an employer just throwing out non-competes. You know, the caution there is actually take some time and make sure it's a right fit for your business.
If you find yourself asked to sign a non-compete, what are some steps that you can take to protect yourself or to fully understand what it is that you're signing?
You know, that's about the worst thing is just signing it without reading it, without understanding it. So that's step one, is sit down. If the employer is pushing you, I need this now, you know, that immediately is a red flag that something's amiss here. But take your time, make sure you understand it, and then push that to the next step is if you understand it and disagree with it, you know, negotiate back. Okay. So if you don't understand it, is that something that people can come to you and have you explain to them? Yes, exactly. What they're signing? So we work with both the employers and the employees on non-compete, so we see both sides of the fence. We always strive to have a reasonable agreement for everyone involved. Right. But yes, if you're an employee and you're presented with it, very much so, you can come to us and we can help sit down and walk through it. Explain, okay. And then if you see something in that you are uncomfortable with, what would be your next step? How would you go about, like you said, negating that or? Yep, so the next step I think is to negotiate to some level that's reasonable. And comfortable. For instance, the starting point the employer might have is you can't work in a 30-mile radius of our store. Okay. Maybe that comes down to 10 miles, 15, you know, just because they start with 30. Or where you live. Right, exactly. So it's a contract. It's what the parties agree to. And if you don't agree to some term in there, then you need to push back and support it with whatever reasonable documents or information you have to substantiate that.
So let's say you find yourself in a non-compete that you're uncomfortable with. What would be the steps to going about either getting yourself out of that or negotiating a new term?
So a lot of the same matters we've already talked about. Reread it. Maybe you remember the terms different than what they are.
Right.
So, step one is to reread it. Talk to an attorney, right? Even though the contract's already been entered into, we can assist with how to deal with it. Consider abiding by the terms if it's a geographic or time. Right. What can you do to still live within the spirit of the contract but still make a living?
Right.
And then the last point is always, again, it's a contract so you can negotiate it. Meaning a lot of times what this comes down to is we buy an employee out of their non-compete.
Okay, so that's an option that some people might not know.
Yes. So, some combination of a downstroke of money or money over time, but the employer agrees, okay, I'm willing to release you from that non-compete. You can go about your business.
And what are some things that you do to protect the employer and the employee?
One thing is to look if there's any industry guidelines. A lot of times there'll be a national association or local association that's already kind of tackled this issue and made their suggestions. Right.
I didn't know that.
Yes.
Okay.
So, that gives us some guidance. It doesn't mandate what the terms are, but it's at least a starting point.
Okay.
Right?
That makes sense because you obviously can't know every industry, every field.
Exactly.
Okay.
But then we sit down and really try to appreciate what are the objectives for that employer or that employee, and then work backwards.
Kind of their goals.
Exactly. What are your goals? Establish that first, and then work backwards. What would you need in a non-compete, if at all, to get there? The entrepreneur or the business owner or the employees are kind of learning as they go, right? And so that's
which is terrifying sometimes.
Terrifying. But that's why I think get us involved sooner than later, right? We've dealt with this on both sides before, and so we can sort of advise moving forward. If somebody is presenting you with this and it just doesn't sit right, don't rush to sign it or run into it. Take a step back, take a deep breath, and consult an attorney or whoever your team is, your accountants, your financial advisor, whoever you trust is, step one. And remember, this is it's a contract. It's a legally binding document, so treat it seriously and review it ahead of time.
And know what you're signing.
Exactly. Knowing's half the battle, right?
Yeah. Yes. So it is important to find a good business lawyer. A business lawyer will know how to navigate protecting the employee and the employer, which is so important when you have a new business. Thank you guys so much for watching. I really appreciate it. I hope that this video was helpful for you. And if you have any other business navigation questions, I would love to hear the next video you guys want to see. So subscribe and like, comments. And if you ever find yourself needing a business lawyer in the Tampa Bay area, contact Daniel with Jennis Law Firm.